So, to this person on the device just labeled Mac, would you be Stephen Smith?
My Christian appellate name is capital S, lowercase Tepehen, capital S, lowercase Mith.
Okay, so that would be a yes. Thank you. Deputy Sims. Now calling 24W003208A, the Township of Ypsilanti versus Stephen Cameron Nigel Smith. Deputy Sims, state your name for the record.
Deputy Sims.
Thank you. Okay, and Mr. Smith, you've already stated and spelled your name out. Thank you. Today is the date and time set for an informal hearing in this matter. What I have is a citation issued November 17th, 2024, that charges that on or about that date you did operate a motor vehicle on Holmes Road at or near Ford Boulevard. And when you were pulled over, you failed to disclose to the officer that you had a concealed pistol and a CPL.
If there's ever a strong argument for the Second Amendment, this situation could be an example. Some people act like they are above the law, yet they still carry a weapon in public. That combination naturally raises concerns. When someone ignores the law, it creates a risk for society. Rights come with responsibility, and when that balance is missing, problems are bound to happen.
It looks like you were also cited for having a window tint. I don't have that citation, which presumably means that it was paid. So, again, this is a civil infraction. There is no criminal penalty associated with this, no jail time, no probation. There is, however, a fine. Before we get started, Deputy Sims, was there anything that you wanted to say?
No, ma'am, I'm ready to proceed.
Mr. Smith, as you have likely heard already, you have three basic options when it comes to this citation, and these are your three options. You can accept responsibility, that is basically admit that you did not disclose per MCL 28.425F that you had a license to carry a concealed pistol and that you did not present that immediately to the peace officer when you were pulled over. You can accept responsibility with an explanation so the court can take into consideration any mitigating factors and potentially lessen or eliminate the fine. Finally, you can deny responsibility, that is, deny that you failed to disclose your CPL immediately, at which point we will proceed to the informal hearing. I will swear in both sides, take testimony, and make a decision based on preponderance of the evidence. Which of those three options are you going with?
I want to, may I grant my name to the court and make the court trustee?
You cannot make the court your trustee. The court's role is to act as a neutral referee, not as your lawyer, and definitely not as a personal assistant or trustee. Its job is simply to oversee the process and apply the law fairly. Sovereign citizens push this idea because they believe that if a judge were listed as a trustee over their accounts, it would create a conflict of interest. In theory, that would force the judge to step aside and bring in a new one. They assume this cycle would repeat until no judge could hear the case. On paper, that idea might sound clever. In real life, it doesn't work that way at all. Courts recognize this tactic immediately, and it has no legal effect in an actual courtroom.
But the option 3, as your question, I deny responsibility and I have an explanation.
Okay, so if you are denying responsibility, then I'm going to swear you in and swear in the deputy, and I will take testimony from both sides. So let me explain how this is going to work. After I have sworn you both in, I am going to take testimony from Deputy Sims first, because Deputy Sims is the officer in charge of issuing the citation. That means he's basically the plaintiff. in this matter, okay? Once he has finished his testimony, which you are not to interrupt, it will be your turn to testify. He is not to interrupt you either. After I've heard the testimony from both sides, I will make a decision based on preponderance of the evidence. As I stated before, that is a 49% to 51% standard. So basically, whoever's testimony is slightly more persuasive. This is not a criminal case. It is not beyond a reasonable doubt in this situation. So, do you comprehend everything that I just said?
I do comprehend.
Thank you. Okay, raise your right hand, Deputy Sims, and Mr. Smith, you will have to tell me when it's raised if you're not turning your camera on.
It's raised.
Do you swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth to the best of your information, knowledge, and belief, Deputy Sims?
I do.
Mr. Smith?
Yes.
Thank you. Okay. Deputy Sims, you may proceed with your testimony.
On 11/17/2024, about 3 a.m., my partner and I observed a black Ford Fusion. It was on Ford Boulevard. I believe it had just turned onto Ford Boulevard with tinted windows. Proceeded after the car. It turned into the gas station there on the corner, and we followed it into the gas station and proceeded towards one of the exits. Before it returned to the road, the driver, Mr. Smith, exited and began yelling at us. At that point in time, we activated our emergency lights and conducted the traffic stop there. We made contact with him, explained the reason that we had followed behind him. And when I approached the vehicle, I looked in the vehicle and I observed a firearm on the passenger seat. At no point in time during that did I hear I have a CPL until after the firearm was located. He was detained, his CPL was verified, he was issued the citations and released.
All right, so that's the officer's testimony, and it's fairly straightforward. The officer explains that he stopped the defendant, and the defendant did not disclose that he had a corporal while carrying a concealed handgun. That alone is a clear violation of Michigan law, specifically MCL Section 28.425B, which requires disclosure during a traffic stop when a concealed firearm is involved. Under these circumstances, a qualified lawyer could potentially build a proper legal defense or challenge certain details of the stop. There are legitimate strategies that could be explored when the law is applied correctly and carefully. But instead of taking that route, we're about to see how the defendant chooses to represent himself. Let's listen to how he responds and see how this approach plays out in the courtroom.
Mr. Smith, it is your turn.
I want to mention there's no damaged property or victim under sworn oath. Also, I believe I was being racially profiled. I had been pulled over, which I did stop, and I was let go because I wasn't suspected of any crimes, just as I wasn't suspected of any crimes by him as well, as he mentioned. We had sat in the intersection, which I was in the middle of a DoorDash, and I wanted to get on my phone to see where I was at. When I looked away from my phone, I seen him, the officer, and another deputy, or whoever it may have been, an officer, also sitting in the middle intersection for about 30 seconds, maybe to even 60 seconds. So he could see me through my windshield. While I believe it was racial profiling, considering the area we were in wasn't the best area. So when I pulled, which I did use my turn signal, and it was a stop sign, or it was a light, a signal light. So when the light turned green, I turned right with my turn signal. I also turn signaled into the gas station, which I was going to stop to check my phone, because like I told the officer that had pulled me over 10 minutes before, which I'm sure he heard on the radio call, I was door dashing, which I had admitted to both of the officers. He called another officer in response to what he calls me pulling myself over. He never admitted to pulling me over. He said I pulled myself over. I got out the car to explain myself that I was door dashing and that I felt like I was being harassed because I was just previously pulled over. I did not have a firearm on person, and he didn't have a reason to suspect me of any crimes or try to search my vehicle. I was illegally searched on person without my disclosure. I told him I don't consent to any searches, and they were digging in my pockets. I have a legal license, and I'm not suspected of any crimes. So
The stop was based on a suspected traffic violation, specifically illegal tint on the front windshield. As the officer explained, that was the stated reason the stop was initiated, and it's a standard enforcement issue. I understand that the defendant later suggests the stop was for a different reason, but if the windshield tint was actually blocking visibility, that explanation doesn't really hold up. If the officer couldn't clearly see inside the vehicle, there would be no way to identify who was driving before the stop was made. When you look at it from that angle, the officer's reasoning stays consistent. The stop appears to be about the vehicle condition itself, not anything personal, and that detail matters when evaluating what happened next.
After he said I pulled myself over, he flashed his lights and they kind of like grabbed me up, and I feel like they assaulted me in a way. And after he figured out that I did have a CPL disclosure, which he never gave me time to disclose because it was not on my person. So I didn't feel the need to, because I was not present in my motor carrier for him to be in any type of danger. After he sat me in the car, which I feel like I should not have been detained that way, for about 15 minutes, they let me be on my way with a citation. And I don't believe I deserve the citation. And he doesn't have any evidence of the situation. It's just a presumption with no material.
Does that conclude your testimony?
Yes.
And did you have any evidence or witnesses that you wanted to present?
I have evidence on my phone of me asking him, what their badge numbers was, which they didn't really want to disclose. So I had to look it up on the internet. I have a dash cam, but it was not running at the time.
So before we continue, I do want to apologize because I did actually have the equipment violation citation as well. That is for the window tint. So did you wish to address the window tint specifically?
That's just how the car came. I bought it that way, straight from Ford. So it's free.
In Michigan?
Yes.
Deputy Sims, since I don't think I specifically asked you about the tint either because I had misplaced this on my desk, do you wish to address the window tint?
Yes, ma'am. I'm sure you're aware that no vehicle that comes from the factory has front window tint on it. During his first testimony, he admitted to having window tint and said that we saw him through the windshield, which is not possible at night, but he admitted that there was tint.
May I add something?
You may.
There's they didn't test any window tint for any type of darkness issues or anything like that. It was just kind of an excuse, because that wasn't the first reason that he told me that he pulled me over. It wasn't for window tint. And you can disclose that through the video of his own body cam. They said that they pulled me over because he presumed that I was trying to turn around in the parking lot or evade him, but I was door dashing, like I told the officer that pulled me over before.
So, Deputy Sims, I believe when you testified a moment ago, you said you had noticed the window tint. Did you want to respond to that to me, please.
I guess, what are you asking?
You had stated that you initiated the stop, or at least you started to initiate the stop based on observing window tint. Is that correct?
So yeah, I mean, I was with my partner. So there's also the part of he came off of Holmes Road, if I remember correctly, turned right into the parking lot, and then cut through the parking lot to go back onto Holmes Road. It didn't seem like there was any intention of him trying to stop at the store or anything like that. So he's also cutting through the parking lot.
May I add?
You may.
I did not try to cut through the parking lot, as I mentioned before, and prove to the officer before I was door dashing. And if I would have been on my phone, then he would have tried to get me for that as well. So I safely pulled over to where I could view where I was. And it was his presumption that I was trying to turn around in the parking lot, but my car wasn't parked.
In that last part, he actually made one strong point and one weak one. Let's start with the weak argument. He shouldn't have claimed that the legality of the stop depended on the officer's statement about why he pulled him over. There's no audio or video evidence to support that claim, and even if there were, it wouldn't really change much. He also admitted there was tint on the front windshield. In Michigan, any amount of tint on the front windshield is illegal, so that admission alone gives the officer probable cause to make the traffic stop. Because of that, the stop itself was legally justified. Now, the stronger argument he made was pointing out that the officer didn't actually test the windshield tint. It's possible someone could say there was tint even if there wasn't, and that could help dismiss a minor violation related to the tint. However, even if that part were thrown out, it doesn't erase or excuse the other violations involved in the case.
So the court is ready to make a decision in this matter. So in regards to the B ticket, that is the equipment violation, basically having obstructed vision with window tint, at this point the court is finding you not responsible for the window tint, Mr. Smith, because based on just the testimony today, I don't think there's enough established to confirm whether or not the window tint would have been in violation. Now, regarding the A citation, that being the failure to disclose the CPL, the court is finding you responsible in that matter, and that is again based on MCL 28.425F. Basically, an individual licensed under this act to carry a concealed pistol and who is carrying a concealed pistol and who is stopped by a peace officer shall immediately disclose to the peace officer that he or she is carrying a pistol concealed upon your person or in your vehicle.
May I add, please?
Well, no, because at this point I'm making my ruling, and the pistol was in the vehicle. I understand it doesn't sound like you were in the vehicle at this point, but you were engaged with the officer, and it was your responsibility as the person with the CPL to immediately disclose that you had a CPL and that there was a weapon in the vehicle. So you are being found responsible. Again, this is a civil infraction for a first offense. There's a fine here of $500, and your license to carry concealed is being suspended for 6 months. Now, what I am going to say is that you do have the right to appeal my decision as the magistrate. If you do so within the next 7 days, the case will be reheard by the judge. So,
How do I appeal?
you would have to either consult with an attorney or you can talk to the clerks about getting the paperwork. I cannot give you legal advice. So
Yeah, because I wasn't, as he stated before, sorry, I wasn't actually engaged in a traffic stop. That was the problem.
At this point, the court has made its ruling. This hearing is concluded. I believe that concludes the docket this morning.
Alright, so that brings us to the end of that video. This is one of those cases where I almost find myself hoping the guy figures things out, because he sounds young and at least somewhat capable of doing better. Right now, Society really needs younger people to step up as positive contributors instead of getting pulled into ideas that only cause more trouble. Unfortunately, following these beliefs usually leads people in the wrong direction and creates problems that could have been avoided. A little guidance and accountability could make a big difference here. Now let's move on to the next case. This one involves a sovereign citizen from Wisconsin whose bond was revoked because he treated court appearances like an option instead of a requirement. As a result, he now has to attend future court dates from a secured facility, all because he didn't take the process seriously.
Call 24 CF 1527, State of Wisconsin versus Gregory Robinson for a bail hearing. Appearances.
ABA Cecilia Mark.
To understand what are the public defender's office appearing on behalf of Mr. Robinson, who does appear by video from the Dane County Jail.
Why don't you speak on
There's a copy of the complaint in this matter.
It is a bail hearing. State's position on bail.
Thank you, Your Honor. The state is asking that the court increase cash bail in this case to the amount of $50,000 with all previous conditions to apply. The state is stipulating that any previously posted cash bail should apply to that amount. The defendant have already demonstrated an ability to post some amount of cash bail. He posted $3,000 in this case in late June. He then missed a court appearance. The court set cash bail at $7,500 while applying the previously posted $3,000 in August, and then reduced that amount back down to $3,000, applying the previous amount. So in essence, allowing the defendant's release after the remaining custody. That release was in September. Just 1 month later, he missed court again. He has been out in warrant status for months and had to be extradited here at no small cost from the state. So for this reason, I have all the state's recommendation.
Attorney Woodard.
Objection, Your Honor. I'm pro se in my case, so I don't know why that gentleman is standing there. And I want to speak on my own behalf because I am pro se in this matter.
Hold on one second. Hold on one second.
I have no objection, and that's how he wants to proceed. If you're right, just so you know, you do indicate you do not want a public defender, and that's what I happen to be. So I'm happy to withdraw.
It really wasn't against your will when you think about it. You just explained that a previous judge asked you questions, and you made the choice not to answer them. That behavior can be considered contempt of court, especially when it happens directly in front of a judge. Direct contempt like that can also be enough to violate the conditions of your bond. Courts expect basic cooperation, even if you disagree with what's happening. Refusing to respond usually makes things worse, not better. At this point, it would honestly be smarter to let a public defender speak on your behalf. Right now, the way you're handling this is hurting your own case more than helping it.
Mr. Robinson, this is solely about bail. What do you think I should set your bail at here today?
First and foremost, ma'am, I think it should be reinstated to what it originally was.
Hold on. Actually, I want to make sure you're capable of representing yourself, sir. It looks like you've done so in the past. How old are you, sir?
I'm 41 years of age, ma'am.
Do you read, write, and understand the English language?
Yes, I do, ma'am.
Have you had any drugs, alcohol, or have you had any drugs, alcohol, or medications that interfere with your thinking here today?
No, ma'am.
You fully understand everything I've asked you and everything that's going on, sir?
Yes, ma'am.
All right, what do you think I should do in regards to bail here today?
Well, first off, I want to object to what the prosecutor has said. First and foremost, it's only been one time that I allegedly failed to appear. First and foremost, everything that we filed is being pro se, standing in my own prior persona. And the last thing that I filed, ma'am, was a default judgment. And in this matter, the state has...
Sir, we're here solely on bail. So what do you think should set your bail on here today? Please stick to the argument.
Well, ma'am, first and foremost, I think it should be reinstated because it's not right what the state is doing. She just sat up in open court and just lied and said I missed court multiple times. This is not true. When I was taken into custody, it's because the first time was because the judge that I went in front of, Mario White, jacked my bond up because I wouldn't answer his question. I refused to answer the questions that he wanted me to answer because it's my right. And I chose to remain silent and not answer what he wanted. So he took me into custody to try to make me do a competency hearing against my will.
In this part, the defendant argues that his bond should be reinstated. He says he didn't run, hide, or pick up any new charges, and that he filed all his paperwork on time. He also claims the state failed to respond to his filings and suggests he's being treated unfairly because he's representing himself rather than being a licensed attorney. He goes on to explain that he recently lost his sister and has been in custody during that time, which prevented him from being with his family. He insists that he only missed court once and strongly denies claims that he missed multiple dates. From his perspective, he believes he's trying to do the right thing and is asking the court for understanding and leniency. The court, however, brings the focus back to his earlier behavior. He's reminded that refusing to answer a judge's questions is a personal choice, but that choice carries consequences, including bond issues. Even if someone feels justified, the court still expects cooperation with basic procedures. At this point, both sides have made their arguments regarding bond. With everything laid out on the record, the discussion wraps up and the court moves forward to hear the judge's final ruling on the matter.
But in this matter, I feel like my bond should be reinstated. I didn't run. I didn't hide. I exercised my right. I filed my paperwork, and time again, the state has not responded to any of my filings. Had I been a licensed bar member, all of my filings would have been responded to. But since I am pro se in this matter, they have not awarded me or afforded me.
You're only here on bail here, sir. Only here on bail. Stay focused. What you want me to reinstate? Anything else in regards to bail?
I'm asking for my bond to be reinstated to what it originally was. I just lost my sister.
Thank you, sir.
I just lost my sister December 22nd. I have not had time to go with my family and grieve. I've been in custody since December 12th, and I'm currently in custody right now. So I'm asking for you to do the right thing and allow my bond to be reinstated. I did not bail jump. I didn't catch any new charges, ma'am. In this matter, no new charges. I did not catch any new charges. And I'd appreciate it if the state didn't lie and say that I missed court multiple times, because this is not true. And then you're standing in court, in open court, lying under oath. You're a public servant. I'm a servant.
All right, sir. Focus. You've made your point, and I do see that you only missed court one time on this case, okay? So please continue. Anything else you want the court to consider in setting your bail?
I want the court to consider that I am pro se. I don't have the college education that she has. I don't have the ability to sit up and lie and try to tarnish her character in open court. I just pray that this court and that you, ma'am, have leniency and respect, and I'm here trying to do the right thing.
All right. Thank you, sir. Cash bail was set at $3,000. It was posted. That was not enough to make you appear at court. So I have no choice but to increase cash bail. They had to extradite you in regards for today's hearing. You wouldn't voluntarily appear when you were supposed to appear. I will therefore set cash bail in the amount of $25,000, and I will reinstate all non-monetary conditions. Looks like time limits have not been waived.
Commissioner, that's consistent with my review of the file. Because of the timing of this hearing and the time limits not being waived, it looks like this will be set next week with Judge White again. He is duty judge next week.
Preliminary hearing shall be scheduled accordingly next week, so it is timely. We are adjourning your case, Mr. Robinson. Good luck to you, sir.
Next week, Paris Tompkins.
It's hard to say you want to be out of custody and moving forward with your life when your actions show the opposite. You missed scheduled court dates, chose not to answer questions directly from a judge, and even after being taken into custody, you had to be compelled to participate in the hearing. When you look at the full picture, it starts to seem like the situation you're in is the result of your own choices. At some point, accountability matters. Wanting freedom also means following court rules and cooperating with the process. If those steps aren't taken, the court has very limited options. Alright, that brings us to the end of this video. If there are any updates on this case, I'll be sure to share them with you. If you enjoyed the video, hit the like button. If you didn't, feel free to hit dislike, but don't forget to leave a comment below. Make sure to subscribe and turn on notifications so you don't miss future content. And once again, thank you to Raycon for sponsoring this video.